All stand, please. All persons having anything to do with this sitting of the Supreme Court of Tasmania, draw an eye and give your attendance. Please be seated.
Alan Michael Bustard and others against Melissa Jane Barrett.
Yes, but please, Your Honour, I appear for the plaintiffs.
Thanks, Mr. Cox. Please, Your Honour, I appear for the first defendant.
Thanks, Mr. Brewer. Well, Council have been put on notice that the decision is being published electronically. So I now publish my reasons. That means that an email has now gone to you, Mr. Cox, you, Mr. Brewer, and to your instructing solicitors. An email will also have gone to members of the press who requested it with a copy of the judgment, and the judgment now being published will appear momentarily on the Supreme Court website. For the reasons I have given in that judgment, and from the answers I have provided to each of the questions posed by the 7 key issues set out in the parties' key issues statement, it follows that the first defendant is liable to the test case plaintiff for damages for negligence and for private nuisance. It also follows in principle that she should be liable to each of the other plaintiffs in negligence and in private nuisance, subject to proof of damage. It will also be seen that I have found that the plaintiff's claims in negligence are apportionable claims for the purposes of the Civil Liability Act, notwithstanding the existence of a non-delegable duty on the part of the first defendant. I have limited the liability for loss and damage claimed by the plaintiffs as to 80% in the case of Ms Barrett and as to 20% in the case of Mr Robinson. Finally, I have found that the Civil Liability Act does not apply to a claim in private nuisance, as the only relevant fault feature in private nuisance is reasonable foreseeability, and failure to take reasonable care is not an element of the tort. The Wrongs Act, however, applies to the contribution proceedings between the first defendant and Mr Robinson, and I have found contribution between them in the same proportions as the apportionment I have made under the Civil Liability Act. I will hear counsel whenever convenient as to the terms of the orders to be made in the case of the test case plaintiff. However, as requested of me, my findings and conclusions have been expressed so as to produce a binding ruling that can be then applied arithmetically to the assessed losses of the remaining 399 plaintiffs when their individual claims arise for assessment, either in the course of post-trial settlement discussions or in subsequent hearings as to their individual claims should that become necessary. All that I've just said appears at paragraphs 781 to 784 of the judgment. That is the concluding page, page 142, under the heading of disposition. Mr Cox.
Your Honour, the only order we'd seek is that the matter return in approximately a month's time. I've spoken with my instructors. The 28th of July would be suitable if it's suitable to Your Honour and defendant, or in the week starting the 9th of August.
Well, now, I think I will be sitting in Launceston, but that's not to say that it can't be arranged. Mr Brewer?
I have no difficulty with that date, Your Honour.
Well, what if we listed for mention on that day, Ms Gartland, at 9:30?
Sorry, the 29th it was, Your Honour. I think I said the 28th.
Can we do that? I have listed something for a Saturday just recently. Yes?
28th, 29th of July?
The
28th or 29th of July?
28th or 29th?
29th would be preferable.
29th?
Yes, 29th.
Yes, all right. 9:30 AM for mention.
If it please.
Thank
Please,
you.
Your Honour.
I'll adjourn.
All stand, please. This honourable court now stands adjourned.